My Lords, it is an honour to speak in your Lordship's House for the first time and to do so in support of this bill, introduced by the noble Baroness Williams of Trafford. I'm grateful for the kind words of the noble and learned Lord Garnier and the noble Lords Bach and Davis of Gower. When I succeeded my father in 2002, I never in my dreams expected that I would take my seat. I thought we would no longer be here. But here I am, and after a contested election, if not the sort of election some reformers might endorse. May I begin by saying how welcome everyone here has made me feel. I have received great support from the staff of this House, not least in the library, the digital drop-in, and of course the doorkeepers. I hope this House will forgive me if I say a little about myself. After Oxford, I went to the bar. I practiced under my family name as Guy Mansfield. I was not the first barrister in my family. That was one James Mansfield. In 1772, he, with others, by habeas corpus, secured the liberty of Somerset the slave before the great Lord Mansfield, no relation. James was later Solicitor General and Chief Justice of Common Pleas. His grandson, William, was not a lawyer. He went into the army. He was a distinguished soldier, and he reached the rank of full general. And William Gladstone made him a peer, and he took the title Sandhurst. My great-grandfather practiced a little at the Chancery Bar. My grandfather and father both aspired to be lawyers, but 2 world wars intervened. They both served with distinction and were lucky to survive, but they did not go back to the law afterwards. My early practice covered a wide field, like many in my time: crime, civil and family, and a range of courts. I acted for clients from all backgrounds. I was lucky in my first 2 years to share a room in chambers with the future noble and learned Lord Wolfe. He was a great exemplar. Life was often quite tricky. I wasn't always very good. My wife, not a lawyer, came once to watch me give a plea in mitigation. Ever the kind but critical friend, she said, "Had you nothing better to say?" Some years later, I went off to represent a district council in a planning inquiry. It was my first such. I'd never been to one, never seen one. I was greeted by the planning officer, rather breathlessly, who said, "Oh, Mr. Mansfield, this is my first inquiry. I'm so glad you're here to show me the ropes." Well, I kept my counsel. We survived. We were successful. In 1994, I took silk. I also became a recorder and later a Deputy High Court judge. The 1990s were a time of great change for the bar. The bar had to respond to High Court adversary rights for solicitors, to the introduction of conditional fees. At that time, I chaired in succession 2 bar committees which had to address these. Next, we had the competition inquiry into the legal professions. As a result of that, I chaired the working party which introduced direct access so that people didn't have to go through a solicitor to see a barrister. In 2005, I became chairman of the bar. On my doorstep was the Clementi report. This wanted to introduce widespread change in the regulation of the legal professions. I'm proud that in that year, we on the Bar Council created a new constitution in the space of the year, which took effect from the 1st of January 2006, with a new, separate, independent regulator, the Bar Standards Board, under a lay chair. That was a big achievement, I think. I returned to practice. In 2009, I chaired another working party in response to Sir Rupert Jackson's inquiry into costs in civil cases. This was to look at something called a contingent legal aid fund. We came to the conclusion that government should look at that. That would be a privately funded, not-for-profit scheme to fund civil litigation. Sadly, it went into and remains in the long grass. Not for today, but we must do more to support access to justice in the civil and family courts. In 2012, I took over leading the Foreign and Commonwealth Office's legal team, defending claims by 40,000 claimants for damages, Kenyans, for damages for alleged assaults in Kenya during the Mai Mai insurrection. That trial lasted 232 court days. It was far and away the most complex thing I've ever done. When it finished in 2018, I thought, that's it. I retired and I looked for a change of direction. So here I am. I feel greatly privileged to have been elected. I hope my background shows areas where I might be able to contribute, but I will wish to contribute on a wider canvas too. Turning to the bill, and I shall deal with this quite shortly, I have looked at it with the eyes not only of one who sat in the Crown Court as a recorder, but as a member of the public who lives in this great city and travels on public transport like everyone else. I am conscious the bill has created controversy, and some parts are not necessarily easy. But I suggest its broad principles are correct. Today I shall focus on just 3 of those provisions. First, there are the provisions to protect emergency workers. My daughter is a consultant in the NHS. She works on the wards. She has told me quite a lot of times of incidents of assault, not just in A&E, but actually on the wards. Doctors and nurses deserve protection. Second, I commend the provisions to make different local bodies work together to prevent serious violence. That must be wise. Thirdly, I identify the provisions for the extraction of information from electronic devices. I say nothing about possible improvements by amendment. The principle is sound. I commend this bill to the House.
Thank you. My Lords, it's a pleasure to follow my noble friend Lord Sandhurst and be the first to congratulate him on his maiden speech. As he said, he's better known outside as Guy Mansfield QC, an outstanding barrister. And there was a rustle of silk from his learned friends as they came into the chamber to hear him. As my noble friend said, he's a former chairman of the Bar Council and a deputy High Court judge. As head of research at the Society for Conservative Lawyers, he has campaigned for better provision of legal aid in the civil and family courts, writing that, I quote, "Every man is equal before the law, but he has to get before the law before he can attain that equality." He's also a prominent member of Justice, the human rights charity, focusing on those who have been marginalised by society. Of particular interest to your lordships are his recent papers on the inadequacy of the government's drafting of COVID regulations and the oral evidence he gave to your lordships' Constitution Committee on access to personal data, both relevant to the bill before us. My Lords, I first encountered his powers of advocacy during the 2019 general election, when we were both canvassing on the pavements of Putney. As it happened, one of 2 seats which my party lost. But entirely my fault and not his. Those powers of persuasion will now be put to use in the calmer atmosphere of your Lordship's House, where his professional skills will help us improve this bill and others. He is warmly welcomed, and I hope he will defend me against the whips if my speech now lasts more than 5 minutes. I want to intervene briefly to support the noble Lord Best, who will table an amendment to repeal the Vagrancy Act, and to support my noble friend Baroness Bertin, who will table an amendment on domestic violence and access to housing, with a related plea in support of Stella Creasy's campaign on behalf of children subjected to gang-related violence. 18 months ago, my lord, I asked an oral question on the Vagrancy Act, making the point that it has the unfortunate consequence of criminalising rough sleepers by bringing them before the courts. This isolates them from the support the government are funding through housing and employment as it approaches its bicentenary should this act not be repealed. I raised the matter again in April, pointing out that attitudes to those who sleep rough have softened over the last 200 years, and legislation that refers to idle and disorderly, rogues and vagabonds living in coach houses and stables have no place in modern legislation. The government's review of the Act was commissioned in August 2018 and was meant to be concluded by March of last year. When I asked about progress last April, the answer, in a phrase often used at the dispatch box, was "in due course." But given the statement by the Secretary of State, Robert Jenrick, repeal should not now be controversial, accompanied by amendments, if necessary, that give the police and others the powers they actually need to deal with vagrancy and aggressive behaviour. So I hope the Minister, when she winds up, can say that an amendment tabled by Lord Best will have government support. On domestic violence and access to housing, again, I hope we are pushing at an open door. Along with other noble lords, last Thursday I tuned into a webinar hosted by the Domestic Abuse Commissioner, with contributions from the Police and Crime Commissioner from Nottingham, the Deputy Mayor in London, and a courageous victim of domestic abuse who is now a police officer. And what struck me as coming relatively new to this subject was first the unanimous praise for the action the government has already taken in this field with legislation, with the 2018 Serious Violence Strategy and the introduction of violence reduction units. And secondly, the narrowness of the gap between what is already in legislation and the amendment to be tabled by my noble friend. While the government wants flexibility of local response, the reformers want a clear statement of priorities through a small but important extension of the definition of domestic abuse. And as I understand it, where the guidance says could consider, we want must consider. And I ask whether it is worth sacrificing the goodwill and progress already made by falling out over this, particularly as the Domestic Abuse Commissioner told us the Policing Minister is supportive. In passing, I was concerned to hear that women's refuges refused to take boys over 10, meaning that one family had to return to the home of the perpetrator, and that the pattern of domestic violence is changing with a growing number of assaults by children on adults. Finally, a quick word on behalf of Stella Creasy's campaign. Too many young people, including children as young as 14, are being murdered as a result of being groomed by criminal gangs in their neighbourhood. And the common factor in these cases is the need for families, or in some cases just young people on their own, to be urgently moved to a suitable place remote from the gang activity. But too often the mother's desperate pleas are not taken seriously enough. And again, my lords, the gap is a narrow one. The government say these vulnerable people may be able to access priority housing under existing legislation, but they have to demonstrate further vulnerability first, such as a mental health condition. We think that hurdle should be removed, and I hope to add a bauble to this Christmas tree in committee, further improving what is already an excellent bill.